Good morning. Welcome to our live webinar. Today's topic, something which many people ask me, and I deal with this issue quite regularly, but however, I never done a video on it before. Today will be the first time, and hopefully we can all benefit from this, learn together, and apply to our specific matters. Me for my clients who approach me, or when I appear in court, or when I draft documentation, and you when you're dealing with your child custody dispute, or when you're advising someone else. Many lawyers watch these videos, attorneys, candidate attorneys, advocates, and people that deal with child custody and care matters on a regular basis, so we can all learn. And if you have any comments, please feel free to post it on the Advocate Muhammad Abduroaf Facebook page. I'll keep an eye on there. However, let us begin and try to learn something. Okay, the voice of the child. What are the child's rights in care and contact disputes? It's an important question because do we say that the parents on their own decides what is best for the child? Or do we say, based upon the age of the child, of course, the level of maturity, do we receive, do we allow for the child to give his or her input into a decision which obviously affects him or her? A simple example would be, should this child live with a father or should this child live with a mother? The child is 17 years old, almost an adult. Must we hear what the child has to say? Should we consider what the child has to say? Or do we say, child, you're still a child, you're not 18 years old. When you're 18 years old, you can decide what's best for you. But for now, let the grown-ups, the adults, decide what is best for you. Is that the facts? Is that the case? We will unpack and delve into it in a bit more detail shortly. I am playing devil's advocate now, and hopefully by the end of this short webinar, we will have some answers and understand the matter much better. Before I get into it, a typical scenario which comes to my desk, and where I also play devil advocates with my clients, is when the client tells me the child does not want to go to dad on a weekend. Or the dad comes to me and say, you know what, the child wants to stay with me until the Monday, and the child does not want to return to the mother. What should I do? Should the child stay with me? Then I play devil advocate and I ask the other party, Mom, what if the child now decides the child wants to stay with dad? Would you be happy with that? No, I would not be happy with that. And I ask the father the same question. Would you be happy if the child decides, yes, you have primary care, but now the child decides, no, I want to live with mom? Or when the weekend comes, the end of the weekend, I want to now live with mom. The father said, no, let's follow the order, let's follow the agreement. Therefore, you should consider what the child has to say, but the child does not make that decision. Adults make the decision. However, we have to consider, we have to give the child a voice. Many times, the child has good reasons why he or she does not want to go and stay by the other party, and many times the child has very bad reasons for that. For argument's sake, when the child is with mom on mom's weekend, because dad is a primary giver, mom takes the child to McDonald's, Spur, all the nice places. That's what mom does. They have fun. There's nothing else as homework and assignments because dad took care of that all before the child went with mom or on the mom's weekend, every second weekend. And they have fun. They visit family, visit friends, etc. When the child is with dad, the primary caregiver, life is a bit hard. It's chores, there's homework, there's assignments. Now the child decides Sunday night, I want to stay with mom because life is good here. And by dad, it's hard work, it's homework, it's learning, it's chores, it's responsibilities. But at mom's place, there's an au pair, there's a nanny. Everything is wonderful here. Now, are those good reasons to follow what the child wants? Of course not. Those are not good reasons. We need to unpack. We need to see why the child wants to remain with one parent above the other. Another extreme example would be when the child visits dad. I'm using dad for example. Dad's new wife and her kids from a previous relationship are not nice to the child. They mistreat the child, they tease the child, they bully the child, and the child does not like it there. Now, that could be a good reason to listen to the child and decide now what is the best way to deal with this matter going forward. Do we limit contact a bit, or do we change contact? Do we change the days? Do we change the scenario? Do we change the dynamics, etc.? There, it makes sense to listen to the child and maybe do something about it. And in the same way, if the child wants to stay with mom because mom gives the child a lot of attention and care on the weekend and having fun, that's obviously mom's prerogative. She's entitled to do that because dad makes sure the homework is done during the week. But mom, of course, under my scenario, she cannot care for the child during the week because she works. She works entire day, early morning till late the evening, and she only has those 2 weekends a month to actually take time off work and spend time with the child. Now, let us unpack the law. I will be very simplistic here. I will not refer to case law and various legislation. I will not refer to the Constitution because the Constitution obviously says the child's best interest is of paramount importance. However, let us look at the Children's Act 38 of 2005. Section 6.5, it says the following. A child, having regard to his or her age, maturity, and stage of development, and a person who has parental responsibilities and rights in respect of the child. So the child, and of course the mom and dad, if they have those parental rights. Mom always has it, but dad may acquire it. Let us go on. Where appropriate, must be informed of any action or decision taken in a matter concerning the child which significantly affects the child. So here the law says, if a child is affected by a decision being made, the child needs to be informed thereof. I'm not worried about the parents here. I'm focusing on the child in the specific webinar. So the child needs to know. So if one party went to court, is going to court, or there's a change in circumstances, whatever the case may be, the child needs to be informed about that. Obviously, based upon the child's age of maturity and development. A child of 2 years old, I do not think it's necessary to inform that child on important things, unless it's most probably something the child can comprehend. For example, they know child, now you'll be living with dad, no longer with mom. That could be, it's important to let the child know. The child will most probably find out in any event. But if the child is older, let's say the child is 12 or 13, he or she has friends at a specific school, neighborhood, and so on. Now a decision has been made for the child now to live with the other parent, new school, new neighborhood, and so on. So obviously the child needs to be informed about that. But that's only informing the child or informing the relevant stakeholders. Let us go further. What does the Children's Act say regarding the child's participation? More specifically now we're dealing with a topic, the voice of the child. Section 10 says the following. Every child that is of such an age, maturity, and stage of development as to be able to participate in any matter concerning that child has the right to participate in an appropriate way, and views expressed by that child, or by this child, apologies, must be given due consideration. A due consideration by who? By the social workers, by the courts, judges, magistrates, by me, the advocate dealing with this matter, or my attorney dealing with this matter. We have to consider what the child has to say, depending upon the child's age of maturity and stage of development. For argument's sake, if the child is very immature, very playful, the child does not necessarily know what the child wants, we might not listen too much what the child has to say, but we will listen, or we will delve into, does the child feel comfortable with either of the parties, and so on. However, if the child is mature enough, I would say 12, 13, 14, that's a very mature age for a child. Dealing with child matters, because the child gets affected by whatever decisions are being made. In that specific scenario, in that specific circumstances, my argument and what I will stipulate is you need to strongly make an effort to listen to what the child has to say and give due consideration, as the law says, to the views of the child. So that is child's participation. The child needs to participate in decisions that are being made. Then we're dealing with major decisions involving a child. For example, what school the child should go to, the relocation of the child from one country to another, passport applications, those type of very important things regarding a child, medical procedures, etc. Section 31, subsection 1 says the following. A. Before a person holding parental responsibilities and rights in respect of a child takes any decision contemplated in paragraph 3 involving the child, that person must give due consideration to any view and wishes expressed by the child, bearing in mind the child's age, maturity, and stage of development. So, I'm not dealing with subsection 3. You can look at the Children's Act yourself, but it's important decisions regarding the child. You have to consider what the child's views are regarding that. It's very important. You should, when the court says duly consider, you need to apply your brain, and you have to now apply your brain in such a manner that it might sway your initial decision or where you're going to. If you considered it and the child's reasons are not, in your view and the other parent's view, valid, and then that's fine, and you can continue, try to explain to the child why you're taking a certain decision. However, if the child's views are valid and it is deemed appropriate to follow it, or to consider it, or to give it some weight, you need to do that. So, ladies and gentlemen, that is my short webinar on the voice of the child. The law expects you as a parent, you as an attorney, an advocate, of course, the presiding officers, magistrates, judges, clerks of the court, and so on, to give weight to the views expressed by a child in a matter concerning that specific child. It is very important. So this is the beautiful thing about the Children's Act, because it brings about a very broad application of the principle of what is best in the mind of the child. It's really what is in the child's best interest. Obviously following what the Constitution has to say, because it will not be in the child's best interest if the child's voice is not heard and his views are being considered. Thank you very much, and I hope you have a lovely day and a lovely weekend, and stay safe.